How to prove your slip and fall claim. It goes without saying, in today's day and age where we have access to all these mobile devices, iPhones, etc., the starting point is always to take a picture of what caused you to fall. Now, that's easier said than done when you're on the ground in agony. But if you can, you should always take pictures of what caused you to fall. And why it's important to take pictures of what caused you to fall is because conditions can change very quickly in Ontario or Canada. If your claim involves snow and ice, well, snow and ice can melt. If your claim involves slipping in a mall or grocery store on water, well, employees can come up and mop it up quickly. It's very important to take photos to clearly document what the hazard was. But it's not only important to take photos of what you saw, it's also important to take photos about what you didn't see. And frankly, it's about what you didn't see is just as important as what you saw. And what do I mean by that? Well, you didn't see any hazard or pylon signs. You didn't see warning signs. If there was a hole in the ground, you didn't see any paint around the hole. Things that you would think are important in a photo, for instance, mats. Well, the area you fell in, there were no mats, but everywhere else, there are tons of mats. So things that you didn't see can be just as important as things that you did see. Now, if you fell on a puddle of water or a hole in the ground, it's also important to document the size. So in many circumstances, that doesn't mean you can take a picture with a ruler, although that is preferable, but you can take photos in a manner that can show the context of the size of, let's say, the puddle. So if you put your shoe beside the puddle, or you take photos from further back so that you can get the context of what the hazard is, that's extremely important as well. And when it comes to holes in the ground or potholes or differentials in heights that led to a trip and fall, it is important to document the depth or the differential in height. And in fact, the law goes even further and says that really what is considered a hazard, although it depends on the circumstances of each case, a general good rule is to make sure that the hazard is at least 3/4 of an inch or more. The greater the differential, the more of a hazard it is, as far as I'm concerned. So after you've done these basic things like take photos, take measurements, show the context of the area, it's also certainly important to get the names and identity and the contact information of witnesses. A lot of people just get people's names. And again, it's in the heat of the moment. You're hurt, you're on the ground, you speak to somebody, they tell you, oh, my name's Peter. And that's great. But when you need Peter's help, Peter's going to be long gone. So you got to make sure that you get their contact information. What does that mean? Full name, address, telephone number. Why do you need their address? Why do you need their full name? Because often their telephone number may change. You may no longer be able to track them down. You may only speak to these people 2 months, 3 months, 6 months later. So you need to get as much information from them as possible. If they'll even show you their ID so you can take a picture of their identification, which a lot of people will just let you take a photo of their driver's license, even that is helpful. So identifying witnesses is super important, but it's not only witnesses that may be helpful to you. It may also be that there were employees or even a manager. You should get their names too. They may be less helpful and they may not give out their full name. They may not give their telephone numbers out, but in any event, even if you get their first name, you get their badge number, you get their role, all that information and their full particulars can be determined at a later date through the litigation process. So you also want to go about, if you can, reporting the incident. Why do you want to report the incident? Well, it's very simple. You don't want them to deny that it even happened on their property, which is one of their first defenses. Their first defense is, oh, well, how do we know this even happened on our property? We have no record of it. Well, give them a record, report it. And reporting it is different than the notice requirement. Although it can serve as a form of notice and may even be sufficient in many cases, it's no substitute for giving formal notice in accordance with the law or the actual statute that specifies how you have to give notice. So reporting the incident is by completing an incident report form. Many entities, large grocers, large malls, large commercial entities, even small commercial entities, have incident report forms. Fill them out, provide your information. Often they won't let you do the writing. So if somebody else is filling it out, like the store manager, make sure that it's accurate. If it's inaccurate, don't sign it. If it's accurate, it's okay to sign, but accuracy and when lawyers look at things and how lay people look at things is very different. Incident report form. You don't want to just specify that you fell. What you want to specify is that you fell on a large puddle of water, that you fell on an oily substance, that you fell because there was a large pothole, a deep pothole. You want to specify the actual cause and the hazard of your fall. And you want to do that contemporaneously or soon after the fall. And even if you fell on one day, it's okay to go back to the store, the commercial organization, the private residence, and report it. Now, obviously, private residences, like someone's home, they're not going to have incident report forms, but apartment buildings do. Apartment buildings often and condo buildings often have security. Fill out an incident report form. Make sure that there's notations. Make sure that they're aware that you were involved in this fall so that they can't deny it at a later date. And filling out incident report forms and giving them notice serves other purposes as well, like making sure that they preserve the CCTV or video surveillance that can often exist in many of these organizations. Most people know that everywhere you go now, there's some sort of surveillance. Chances are that surveillance not only caught you falling, but it also shows the aftermath, and it may even show the hazard. These are all things that will help solidify your claim. But before you leave the scene, make sure that you get all these things done. Make sure that you document as much as you can relating the circumstances of your claim. And if you're immobile and you can't leave, call the ambulance. An ambulance will come directly to you. But when the ambulance comes, make sure you tell them what you should tell everybody else, which is why you fell. I fell because I slipped on a puddle of water. That you injured whatever you injured, your knee, your back, your head, your whatever. And make sure, because the ambulance call attendants write all this stuff down. And just like my advice with respect to incident report forms, it's the same thing. Don't just tell them you fell, because that'll be used against you at a later date. Make sure you tell them you fell because of water, because of a hole in the ground, because of this or that. And make sure that you confirm with them and make sure they understand that you injured a certain part of your body. You also want to document the footwear that you were wearing. Often, it is suggested that the reason why you fell was not because of a hazard, but because you were wearing bad footwear. You were wearing flip-flops. The soles of your shoes were worn out. You weren't wearing boots. You were wearing shoes in wintry conditions. Again, insurance companies have a million excuses. So, what can you do? Preserve your shoes. Take photos of your shoes. Take photos of your footwear. Take photos of the tread on your footwear. And take photos of yourself, either at the scene or shortly thereafter. So after the ambulance call attendant comes, they take you to a hospital. Make sure when you are in the ER or with the nurse in triage, you tell them the same story that you've told everybody else. That you fell because of water, a puddle of water, and you injured your knee. Again, just simply telling people that you fell is insufficient. Okay, there's many, many reasons why people fall. It does not mean that somebody else caused your fall. So we need to make sure that we have this consistent theme and consistent documented evidence throughout your claim that you fell because of water and you injured your knee. And you also want to make sure that you tell the medical practitioners all the problems that you have. Yes, your knee might be your worst injury, but what about your wrist? What about the fact that you now have headaches? What about the fact that your neck is sore? Do not overlook what you perceive are the more minor or less significant issues. I've seen it countless times, too many times, where my client has broken their ankle and they thought that that was the primary focus. Everybody was focused on the broken ankle. Why? Because the bone is almost sticking out of the skin. It's drastically deformed. You're in horrendous pain. And everybody's focused on just the ankle. But what they didn't write down was that you landed on your shoulder and that you really hurt your neck and that you smashed your head on the ground. So all the focus is on your ankle for good reason. It's going to need surgery. But when you omitted your shoulder or your neck, and now 3-6 months down the road, while your ankle, despite being operated, is still in the process of healing, but now your shoulder's killing you and you can't lift up your arm. Chances are you've torn your arm. But it's never been mentioned. It's never mentioned because everybody, including yourself, was focused on your ankle. Well, so what does that mean in terms of your lawsuit or your claim? Well, now Guys like me will allege that your shoulder was also injured in this accident. And the first thing that the insurance company and their lawyers do is say, well, you didn't tell anybody about that. The first report of your shoulder is only 6 months after the accident. It has nothing to do with the accident. It wasn't caused by the accident. According to them, it just mysteriously appears. So you got to make sure that you document everything. And I use the term, don't suffer in silence. What does that mean? It means you have to complain. You have to disclose everything that's bothering you. And a lot of people say, I'm not the type of person that I don't like complaining. And that's fine. I respect you if you're that type of a person. But when you're dealing with insurance companies and litigation, they're going to throw all that in your face. They're going to tell you that why you look into us for compensation for your shoulder, the fact that you can't use your dominant right arm anymore. That's not our problem. That wasn't caused by the accident. You've never even complained about it. So when you go to the doctor, whoever it may be, make sure that your doctor is aware of all the problems. Headaches, inability to sleep, even if you're depressed after the fact, that your back's hurting, your knees hurting, your ankles hurting, whatever it is, make sure that it's properly documented. Often, your doctor is also going to give you some advice. A lot of people don't follow their doctor's advice, which is very surprising. Your doctor tells you to go for treatment or go for an x-ray or go to this specialist. You better make sure that you go. It's very important to follow your health practitioner's advice. And it further can be used to further support your claim as well. So if they refer you to physiotherapy, go to the physiotherapist. And again, confirm the same thing that I've told you earlier. I slipped and fell because of water or a puddle of water. I injured not only my ankle, but I also hurt my shoulder, my wrist, and my neck. I also now have these horrible headaches. Yes, I know I'm here to rehabilitate my severely broken ankle, but my shoulder is also killing me, and my headache is unbelievable. Continue to repeat the same thing so that it's consistent throughout your claim, making sure that each clinician that sees you understands the full scope of the injuries that you are suffering. After you've gone for treatment, then you also have to comply with these notice provisions that I've discussed in a previous video. I've highlighted to you in this previous video the importance of complying with notice periods. Notice periods are not something that you want to screw around with. Fortunately, for most claims involving private property, no notice is actually required to be given. However, claims involving snow and ice, you have to give notice within 60 days. And often, once you've given notice, you're going to receive a phone call out of the blue. And you know who that phone call is going to be from? It's going to be from what's called an insurance adjuster or a representative of the large commercial entity that you are at. And they're going to be very friendly with you, and they're going to be awfully concerned about your well-being. And they're going to encourage you to give a statement. They're going to encourage you to meet with them in writing. They're going to encourage you to sign all these release forms to give them all kinds of information about you. And my advice to you is you want nothing to do with these people. They are not here to protect you. They are here to represent the insurance company and/or the entities that they represent. They do not care about you. Their duties are to make sure that their clients' best interests are looked after, and their clients' best interests are opposed to what your best interests are. So you never want to give these people a statement. You never want to meet with them, and I frankly never ever permit it. And in fact, I go even further, and it's common sense, but in my entire practice handling thousands of these claims, I've asked insurance adjusters countless times, if you're going to interview my client and/or cross-examine my client, am I going to be able to meet with your manager or your stone owner or your contractor? And I'm still waiting for them to say yes. So you have to ask yourself, well, why won't they allow me to? Why can't Preszler, me, interview their clients? Well, they know why. It's the same reason why I would never allow my clients to give statements. But yet I still hear from many members of the public that, oh, I spoke to this lawyer or I spoke to this person and I gave a statement. Unless you're required to give a statement by law, do not ever give a statement. There will be a time where you give a statement. It's called examinations for discovery. Examinations for discovery are a part of the litigation process where you will have to give formal evidence and you will be asked a lot of questions by the representative of the insurance company or the entity in which the litigation has ensued. And they're going to ask you all kinds of questions. And for all those people that gave a statement 3 years ago or 2 years ago or whenever they did with this insurance adjuster, don't think for a second that if anything that you say is different 2 years later or 3 years later, you're now a liar. At least that's how the insurance companies will try to paint you. So you don't want to ever give statements because it's an opportunity to undermine your credibility and or to suggest that there are inconsistencies in your story. They'll suggest that that statement referred to things like, oh, you didn't mention your shoulder, you didn't mention your neck, you only focused on your ankle. And the answer generally is, oh, well, he didn't ask me about anything else. And they'll say, well, you signed the statement. You could have added stuff in, couldn't you have? But in those circumstances, you didn't know what you were doing. You just figured that this guy was genuine and that he actually wanted to make sure that your well-being is being looked after. Well, wrong. Guess again. Now it's going to come back to hurt you. So you're always better to err on the side of caution. Don't speak to anybody that represents either the insurance company, the commercial entity, the private entity, whatever the adverse party is, the other party, stay away from them other than giving notice. It is never in your best interest to do so. When they call you, be polite, advise them that you're not comfortable making a statement with them, that you're in the process of hiring a lawyer, and that lawyer will provide all the information that they need to answer the questions that they have, if that lawyer deems it appropriate. So it's very simple. The process is either don't accept their calls, or if you do speak to them, because they can also come to your house and knock on your front door, just simply tell them that you don't feel comfortable, be polite, you have nothing to hide, you're the victim, that you have nothing to say to them, that you're in the process of either retaining a lawyer, give the adjuster your lawyer's contact information, and your lawyer should reach out to them and give them the answers that they need. So at this point in time, you're either one of two people. You're either the kind of person that is deciding that, you know what, I've been profoundly affected by this fall, and I think it's time to hire a lawyer. Or you're the other type of person that thinks that, oh, I'm not the type that litigates and I'm not going to do anything about it. I'm not interested in dealing with lawyers. And before we jump to my next video, which talks about the importance of complying with limitation periods, I want to remind all those people out there, because I hear it all the time. Most people that call me say to me, Jeff, I'm not the type of guy or person to litigate. I'm not one of those people. And I want to just speak to those people directly, which is you only get one kick at the can in Ontario or in Canada. And there are very strict notice and limitation periods that have to be complied with. And if you miss those notice or limitation periods and you don't get better, we all hope you're going to get better. And we all hope that you're not going to have long-lasting problems. But if you're one of those people that think that this isn't a big deal and that your problems are going to go away, well, I've got a news flash for you. You have to comply with limitation periods, because if you miss that limitation period, you may have no recourse at all. Even if, let's say, 3 years down the road, now all of a sudden you can't do your job. Well, guess what? I've had to be the bearer of bad news to many people where I have to tell them you've missed the limitation period completely, and you knew that you had a problem. You knew that you suffered damages. You knew you weren't getting better. You knew who caused the injury, and you knew you could have sued, but you chose not to. And now you got to sleep in the bed that you've made. So I encourage everybody to click on the link below, watch my videos. I can help direct you through the process. And most importantly, at a bare minimum, educate yourself on what the process is going to be like and what you need to do to make sure that your rights are protected and that you don't compromise your future.